Namaskar class, this is Jv'n Devashree Awasthy. Today topic is Introduction to Indian Contract Act 1872. The Indian Contract Act occupies the most important place in the commercial law. Without Contract Act, it would have been difficult to carry on trade or any other business activity. And in employment law, it is not only the business community which is concerned with the Contract Act, but it affects everybody. The objective of the Act is to ensure that the rights and obligations arising out of a contract are honored and legal remedies are made available to those who are affected. Basically, what is contract? According to Section 2S of Indian Contract Act 1872, an agreement enforceable by law is a contract. Therefore, there must be an agreement and it should be enforceable by law. The agreements are not enforceable by law are not contract. An agreement means a promise or set of promise forming consideration for each other, and a promise arises when a proposal is accepted by implication. An agreement is an accepted proposal. In other words, an agreement consists of an offer and its acceptance. Here are some important definition. Offer. As per section 2a, when one person signifies another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Acceptance. As per section 2b, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be acceptance. Promise. As per section 2b, a proposal when accepted become promise. In simple word, when an offer is accepted, it become promise. As per section 2b, consideration. When at the desire of the promiser, any other person has done or abstained from doing or does or abstain from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called consideration for the promise. Price paid by one party for promise of the other. Technical word meaning quid pro quo, that is something in return. Agreement. Section 2 is said every promise and set of promises forming the consideration for each other. In short, agreement equals to promise plus consideration. Void agreement. An agreement not enforceable by law is called void agreement. Types of contract on the basis of validity. First, valid contract. Second, void contract. Valid contract means we satisfy all the requirements prescribed by law on the basis of creation. The word void means not binding in law. Accordingly, the term void contract implies useless contract that has no legal effect at all. A contract which ceases to be enforceable by law because when of ceases to be enforceable. Voidable contract. According to section 2, an agreement which is enforceable by law at the option of one party or more of the party but not at the option of other is a voidable contract. Thus, voidable contract is one that is enforceable by law at the option of one of the parties. Unenforceable contract, where a contract is good in substance but because of some technical defect, that is absence is writing by limitation, one or both the party cannot sue upon, but it is described as an unenforceable contract. Illegal contract. It is a contract which the law forbid to be made. An illegal agreement is void, but all void agreement or contract are not necessarily illegal. A contract that is immoral or opposed to public policy is illegal in nature. Unlike illegal agreement, there is no punishment for the party to void agreement.